Right? Oyez, oyez, oyez. The Court of Appeals of the Fourth Appellate Judicial District is now open pursuant to call.
You may be seated. Good afternoon and welcome to the Fourth Court. I will be presiding over this afternoon's oral arguments. To my right, I have Justice Lori Brissett, and to my left, we have Justice Todd McCray, and we welcome you to the Fourth Court. At this time, I'm going to call the case. So if you could please give me your announcements. The court calls the state of cause number 4-24-311 CR and 312 CR. The state of Texas versus Alejandro Contreras.
Get up for the state. Good afternoon, Justice Jordan from the staff.
Welcome. Thank you. Each side will have 20 minutes to present their oral argument, and then Mr. Guerra, you will have 10 minutes for rebuttal. Will you be splitting any time with anyone? I see that you are alone at council table.
That's correct, Justice Rios. I won't be splitting my time, just me.
All right, thank you. You may proceed.
May it please the court. Flores v. State has led to confusion and to hardship for prosecutors when attempting to indict offenses that utilize the reckless mens rea, in particular manslaughter and aggravated assault with deadly weapon offenses, which is what we're here to deal with today. This situation here, the indictment that's at issue in this case, is the state's attempt to navigate within the confines of Flores v. State, which is what my first argument concerns. I just, since you've all read my brief, wanted to draw your attention to a couple of things I don't think I was clear enough in my first argument. After that, in discussing my second argument, I'd like to just go over the past 7 Court of Criminal Appeals cases that tackle this issue concerning 2115. So first, Flores is it's a decision that requires extremely close reading, because in Flores, when you look at the analysis and the holding in the case, the court draws attention to the appellant's argument that there was an or connecting each of the allegations in the indictment. And in fact, in the holding, the court only focuses on one of the 3 manners and means that were included in the indictment. If you recall, in Flores, we have, and I'm just going to generalize, I'm not going to quote them exactly to save time, they are long. We have 3 manners and means. We have speeding, we have going straight in a left turn only lane, and we have racing. But in its decision, the court only analyzed speeding. And the court only said that's only speeding. In that circumstance, it could have gone further, but it didn't. Or this court could have gone further, but it didn't. Said that that was a failure to comply with 115 of the criminal procedure because of the or connecting it. So you would look at speeding in a vacuum. It is because of that that the state in its next indictment neglected or decided not to use or in its indictment. And I know the first question you're thinking will be, what about the lack of the and in the indictment? And the state is reluctant to include and in an indictment also, because in Flores v. State, in that same opinion, and would assert to you perhaps that the part at issue of Flores v. State is dicta, since the holding is, of course, on a harm analysis. But in the holding, it recognizes what I'm here to discuss with the court, that manslaughter is a result of conduct case. And because it's a result of conduct case, the jury does not need to agree on each of the manner and means. And because of that, the state risks in putting and it's an indictment, defense's ability to argue that because we pleaded it that way, we must prove it that way, and that the jury would have to be unanimous. And so Flores puts us in a very particularly precarious situation with these indictments. And it is my assertion, as you know, that we have complied with Flores in this instance. I want to move on, and I want to start.
Can I ask you a question in regards to that? Are you saying that, are you taking the position that if you went to trial and you were not able to prove the last two parts of your indictment, and you only were able to prove speeding, unlawful failure to maintain a proper lookout, for example, that would be sufficient for a reckless finding.
That's correct. That is my position, and that is the position that Flores takes in its harm analysis. The Flores court says that the state does not, or the jury does not have to agree on each one. Thank you for the question, Justice Brissett. And so,
Can I follow up with a question?
yes, Justice McCray.
So the trial court in its order, setting aside the indictment, and I'm going to quote here, even though the state has alleged these acts in the conjunctive, and are you conceding that you've alleged the acts in the conjunctive?
I am not. And thank you for pointing that out, Justice McCray.
Let me finish. They need only prove them in the disjunctive, referring to proof. But we're at a hearing on whether the indictment should be set aside or not. We're not here to look at proof. We're here to look at notice and the sufficiency of the indictment. So I'll go further. The law allows the defendant to be convicted if the state proves that the defendant committed just one of the alleged acts. Therefore, all of the allegations of the acts constituting recklessness must be complied with in Article 2115. So assuming we're not constrained by Flores, what's wrong with this approach? Or what authority exists that we should reject this approach?
Oh, excellent question. And that gives me a great leeway into my next topic. Although I do want to make it very clear initially that the indictment in this case did not include an and. The trial court mistakenly added the and in its own paper that it wrote. And I think that goes to indicate that when it seems to indicate.
So it was
that people-
intentional.
Right, correct. And so in this situation, for example, let's take what the trial court had a problem with, let's say just speeding. If the state proves that an individual was speeding, but that speeding obtained a level of recklessness that caused the death of an individual, then yes, I think if I'm proving just one of those allegations, then the state could, I guess you're talking about conviction, but that does notify defense because that's exactly what the law requires. And the reason for that, and that'll move into my second argument, is that manslaughter and aggravated assault with a deadly weapon are both result of conduct cases. And I want to draw y'all's attention to some of the particular nuances in the recent CCA cases that analyze 2115 in this way. There's 7 cases. The most recent 3 all analyze circumstances of conduct cases. And then prior to that, the prior 4, and then there's 3 smaller ones, but we'll just look at the main 4, all analyze result of conduct cases. And I think that the confusion out of that is where was what led us to this argument here. You see, in State v. Rodriguez, which is the most recent case, the offense at issue was recklessly discharging a firearm in a public place. And that's the famous case, I'm sure you all remember, where the state pleaded a tautology, discharged a firearm by discharging a firearm. And the reason, of course, that that's incorrect under both 2115 and 603C is, if you recall, in 2115, the second half of the statute states, in no event shall it be sufficient to allege merely that the accused in committing the offense acted recklessly or with criminal negligence, and to allege that somebody recklessly fired a gun by firing the gun. The state did just that. And I think that situation is quite different than what we have here. And the reason it is because recklessly discharging a firearm, as you know, along with indecent exposure, the offenses from Smith and Genginal, are both circumstances of the offense cases are. These are offenses that criminalize innocent behavior that becomes criminal under certain circumstances. And the Penal Code in Section 603C, and this is what I assert, that must be harmonized with 2115 under Smith v. State, that, well, the statute says a person acts recklessly or is reckless with respect, or excuse me, there we go, with respect to the circumstances surrounding his conduct or the result of his conduct, when he's aware of but consciously disregards a substantial and unjustifiable risk that the circumstances or the result appears. And it follows that in a case where the state is attempting to criminalize innocent behavior, but for these circumstances at 2115 would require the acts necessary. And Rodriguez, that did not occur. And the same with Smith v. State, obviously because, well, I don't want to say obviously, it may not be obvious to some, but the act in both of those cases of exposing oneself without any other information is not criminal behavior. And so it makes sense that these indictments failed to notify the defense what they were accused of. However, once you get, and I want to draw your attention very closely to the holding in Genginal v. State. That's a 1988 case, and that's the situation where we have, well, I just want to read you what the holding was. It says, in order to comply with Article 2115, the state must allege circumstances which indicate the appellant was aware of the risk that another person who was present would be offended by his act of exposing himself and that he acted in conscious disregard of that risk. That holding tracks the language of 603C with respect to a person acting recklessly because he or she is aware but consciously disregards a substantial risk that the circumstances exist. In indecent exposure, the statute itself also includes additional mens rea, which must be described, and that is that you are reckless with respect to another person being present. And so the act we're looking for in that case was in public, right? And when you go further back and you start looking at cases that are result of conduct cases, we start with Kroom v. State, we find the Court of Criminal Appeals applying 2115 in a different way, but a way that is still consistent with 603C. Now, Kroom v. State is a case where the defendant caused the death of a complainant by failing to guide his vehicle away from the complainant and by failing to keep a lookout. And the court is very clear on its question that it answers. It says, its question is whether these acts constitute recklessness. That's it. And the court says it does. It says it's the appellant's disregard of the resulting death which must rise to the level of a gross deviation from the ordinary standard of conduct. And so these acts, when coupled with the, I would say, most important part of the indictment, causing the death of an individual, or here causing injury as well in the aggravated assault case, we have 2115 applied to require the acts in order to notify, because that does notify.
So are you taking the position that the indictment would be sufficient if it did not include the controlled substance or the use of mobile device?
I am not taking that position. I think that not including those wouldn't change anything. I think that it is sufficient regardless of whether those are included.
You're saying you believe it is sufficient if you didn't have those things?
That's correct.
Okay.
That is correct.
What about the case law? I think it was Gill v. State, that where it said speeding by itself is not reckless. It has to be in the context of something else. Like you might have cases where they're eluding the police or they are under the intoxication. Aren't there cases out there that say you have to have something in addition to speeding?
That's an excellent question. And speeding in and of itself is not reckless. But what we have when we indict somebody, for example, for manslaughter, we're saying this individual sped so recklessly that they caused another person's death.
So Stat v. State, where the truck is going so fast it goes airborne, right? That would be the circumstance.
And any of the other elements that defense is seeking here, how fast the car was going, what the weather was like, these are all evidentiary matters, which under Ross v. State, we are not required to plead. These are factual matters that defense and the state will disagree about, that the jury will decide. The jury will decide whether the weather was what the witnesses said it was. The jury will decide whether the person was behaving in this way or not. Those evidentiary matters make it difficult for the state, or pleading those evidentiary matters in a manslaughter indictment is not required. And it makes it extremely difficult for the state to prove its case.
So then how technically is that different than Flores? Because Flores, they said the disjunctive did not give them notice. And you're saying that you affirmatively didn't make it conjunctive. And so by your own argument, it could be any one of these things. Isn't that disjunctive? The
biggest difference between Kroom and Flores is that Kroom concerns a result of conduct offense and Flores result includes the circumstances of conduct offense. And
that's the distinction.
That's correct. An offense that also includes an additional mens rea requirement of being reckless about whether another individual is present. Those statutes are different. They criminalize different behavior at their core, and so they should be treated differently under 2115. I want to draw this court's attention as well to Arredondo v. State, the state that came before Croom v. States from 1979. Defendant recklessly caused the death of an individual by grabbing a steering wheel and by pulling said steering wheel to the right. There are many circumstances where that is not reckless. What if there's a cow in the road and I'm trying to help my mom avoid it? What if there's a car that switches into my lane? And yet, Arredondo finds that this sufficiently pleads the acts that constitute recklessness. And I want to talk a little bit about the idea of an act constituting recklessness, because I think that's what led to the majority of the confusion. It's briefly mentioned in Smith v. State, and they talk about the Dawes and Dixon article. And I disagree with the idea that an act can't constitute recklessness, because an act, let's put it like this. If I buy a pizza, my pizza has pepperoni and cheese. All of those things constitute a pizza, right? But the pepperoni is still a part of that pizza. And the cheese is still a part of that pizza, and the marinara is still a part of that pizza. And so just because one thing constitutes another thing, it doesn't mean it is that thing. It means it is a part of it. It makes it up. And that's just this, believe that's the lay definition from Webster's. So
is your argument in line with Flores? Are you asking us to distinguish it, or?
well, I'm offering you two alternative arguments. First, I'm offering you to distinguish it from this situation and assert that we have correctly pleaded it. The other argument that I'm making is that Flores, being dicta and also being incongruent with prior CCA holdings, is law that should be aligned with the Court of Criminal Appeals.
It's a nice way to say that.
So I want to draw your attention to a great example, and I love that this case exists, and I want to give you a cite because I didn't include it in my brief, and I'll file a letter with this. Cole v. State from 1977 is a case in which the Court of Criminal Appeals dealt with a result of conduct offense. The offense was negligent homicide, and they found that the indictment failed to comply with 2115 and failed to state the acts of negligence. And what's interesting is the indictment in that case said that the defendant permitted or suffered a motor vehicle under his control to collide with another motor vehicle. He recklessly did that. And that is identical to the Rodriguez tautology. And that's the type of situation where the Court of Criminal Appeals has rejected an indictment by the state. And then finally,
What's the cite for Cole?
Your Honor, I have it right here. The site for Cole v. State is 556 Southwest 2D 343. The pin site would be 344. And so we have a situation where all of the cases in which the Court of Criminal Appeals has applied 2115 with respect to manslaughter result of conduct cases, the court has found that these acts do constitute recklessness, because that is all we're required to put in our indictments is acts, not conduct, not behavior and act, which under the Texas Penal Code, section 107A1, is a bodily movement, whether voluntary or involuntary, that includes speech. Conduct, of course, is an act and its accompanying mental state. That would be section 107A10. But it's important to remember the distinguishing between that. There's nowhere in any law that states for a result of conduct case that we have to plead the circumstances that make the defendant's offense reckless. In doing that and requiring us to plead these circumstances, you're asking prosecutors, or Rodriguez, excuse me, asks prosecutors to file to indict result of conduct cases as if they were circumstances of conduct cases. And that makes it difficult to indict, difficult to try. And difficult and confusing for the courts.
At the hearing below, I know that there was some mention about whether an omission was sufficient to plead an omission, but is that still an issue? I didn't see that on appeal.
I do not think it is an issue, Justice Rios. It was not an issue. And initially, it's an issue I began to research, and then I decided that it was not referenced at all in the court's order. And so I did not ultimately argue that point.
But I just want to make sure I understand your argument is really that despite the language in Flores, and part of it is dicta, I would absolutely agree with you, that it doesn't matter. The disjunctive versus conjunctive is not the issue.
In my alternative argument, that is absolutely correct. In my second argument, the disjunctive or conjunctive really doesn't matter as long as the state lists the acts and the defendant receives notice.
Receives notice of the kind of acts that might be proven at trial.
That's correct. And in this case, Mr. Contreras received notice that he recklessly caused an individual's death by speeding, by failing to apply his brakes, by failing to evade, by driving while there was a controlled substance in his body, by driving while operating a mobile device.
And to your point about that it doesn't matter whether it's pled in the conjunctive or disjunctive, can you point us to a case? And I know that some cases say, hold one way, but can you pinpoint for us some authority that says it really doesn't matter?
Yes, I can. There is a case, Ramos v. State. It's cited in my brief. And there is a quote specifically, well, this concerns the jury charge, but I think that it's applicable in this situation. When you deal with indictments, you frequently go back and forth between those. And the exact quote is, "Therefore, the manner by which the murder is committed is irrelevant so long as the surrounding evidence shows beyond a reasonable doubt that the appellant was reckless and caused the victim's death." And I think with that, it's essentially saying when we allege manner and means, and in this it's a murder, obviously it's not a homicide, so it's a little different, but when we allege manner and means, we don't need to put an and or an or in there. And if you allow me to file a letter after this, I spent, because I'm a grammarian, an extraordinary amount of time researching and or and what it means and reading Garner's interpretation of it as well.
We've had some discussions about grammar in this case.
Yes, Brian Garner in his, I think the 8th edition of Garner's English Usage Dictionary, I think it's in the section for and/or C, I believe. He asserts that if you leave a comma or leave an and an or out of a list of items, and I don't want to say he directly says it, but I think that he implies that the and is understood. And he gave it a clever name, and I can't recall what it was.
Commas usually indicate or imply a series of
I see that I'm running out of time. Would it be all right if I just wrapped up?
course.
Thank you all so much. So when we go down the line, Kroom v. State, Arredondo v. State, Cole v. State, and Townsley v. State, we see that the Court of Criminal Appeals has never increased the state's burden in the way that Rodriguez has. And Rodriguez's opinion, the court's opinion in that case, has caused confusion and even a split between different courts in Texas. For example, I believe there's a split between Houston's 7th and 14th District. Thank you.
Thank you.
Good afternoon, may it please this honorable court. I find it interesting that appellate began his argument pointing out the inconvenience this Flores decision by this court has caused the prosecution. He neglected to mention the only party that is entitled to due process rights and notice. That's the appellate. And the only inconvenience this court should be concerned with is the notice that the accused receives. This court decided Flores versus State. As of this morning, according to Westlaw, it's been cited multiple times, not once negatively. It's a good decision. It was well-reasoned decision. Let me start from the beginning. We're here because my client was hailed into court, 2 very serious indictments leveled against him, charging manslaughter and aggravated assault. And it had a series of allegations of what are alleged to be reckless conduct. One of those, and the focus of the trial, Judge Mary's trial court's order was the speeding. I'm going to call it speeding rather than using the exact word. I think we all know what we're talking about. He said the circumstances that speed under the circumstances that existing. But yeah, we're here because he had a series of allegations leveled against him, including the speeding allegation, and we challenged it because it says there's circumstances then and there. What circumstances? And it struck the court, the trial court. What circumstances are you talking about? It's completely open. You have no idea what they're referring to. Is it because he was driving 120 miles an hour? Was he driving the wrong way? The scenarios are endless. And that allegation, the first allegation, let's just call it the speeding allegation again, conflicts directly with the allegation that was found to be insufficient in this court's Flores decision. There is no principal difference from the speeding allegation in the Flores opinion and the allegation of the indictments before the court today. So the trial court, bound by Flores, was compelled to set aside the indictments leveled against appellee Contreras.
But to do that, do we have to find that even though they take the or out, that effectively it's disjunctive because there's no and?
Let me just say that I disagree with all of the state's argument.
Mm-hmm.
Okay, it's black letter law. Every one of us here learned in law school, criminal law, that you plead in the conjunctive or disjunctive and you charge in the disjunctive. It's the common law. It's all the case law. You will find not one case that says otherwise. Not one. Now, the state said, yes, there is a case lurking out there. It's called Ramos. And he cites it in his opinion. His brief. All due respect, the state completely misinterprets Ramos. Ramos had absolutely nothing to do with the sufficiency of pleading. What Ramos dealt with, the sole issue it was considering, was sufficiency of the evidence. This court has considered sufficiency of the evidence countless times. It's very fact intensive, and it's a different type of analysis than specificity of a charge instrument. The two have nothing to do with each other. And so when you look at legal sufficiency, the standard is very low. Is there any evidence out there at all that would support this allegation? That is different from, does the pleading pled with enough certainty to support and charge this offense? I think the justices can see that Ramos had no application to this. While the language on the surface may appear to apply to this, it doesn't, because it was a sufficiency, a legal sufficiency at that, not even factual sufficiency, legal sufficiency. So I want to make that real clear. So Judge Brissett, let's get back to you. You broached disjunctive versus conjunctive. And I think that's real important because the state puts a lot of weight and attaches a lot of significance to that. Just because you leave out or and does not create a third category of pleading. There's two categories of pleading manner and means. It's disjunctive or conjunctive. There's no third.
Which one is this one?
This is disjunctive.
Why?
Well, the reason for the practical, let me back up, say that it doesn't matter.
Okay.
It doesn't matter. Kitchens versus state. It's cited, I think, in both our briefs. It says you can plead in the conjunctive or disjunctive, and you're still going to charge in the disjunctive to the jury. Mm-hmm. The jury's going to get them all either way, whether you separate them by commas, by ors, by ands, or by nothing.
And they don't have to agree on which one it is.
They don't. It's non-unanimity doctrine in Texas. So they can all say, well, you get what that means. They can all say, we agree with he was speeding. No, he probably wasn't speeding at all. He should have kept the lookout. And they don't have to explain which one they found. There's no special verdicts in Texas.
Mr. Contreras, so
Yeah, Your Honor,
part of the requirement is also to make sure that the defendant can prepare a defense.
you're right.
So the indictment as charged or as written, how did it impede an ability to prepare a defense?
It would have some a near crippling defense. Let me tell you part of the problem is that can I answer your question? And I don't want to be long-winded and answer your question because it sounds like I'm evading it, but I'm going to wind back to you. I want to start off by talking about Townsley. Townsley is the opinion, if you know, we've cited a bunch of cases, but Townsley's the case where the guy was speeding down the road, an officer gets behind him, he flees from the officer.
Yeah, it
ends
said
up
while
flip-
eluding. Yeah, right.
he ends up flipping his vehicle.
Mhm.
Okay, and in that case, the way it was charged, it said fled from the officer while.
While
That
eluding.
word is golden.
Mhm.
While, not a comma, not an and, not an or, but a while.
Mhm.
While evading police and flipped his car, resulting in death. What that means, it was charged as a narrative, one manner and means. That is one manner and means. And Townsley is cited more often than I think any other case because it's so perfectly proven. And alleged. And the reason for that is any defendant who reads that, Judge Rios, Justice Rios, I have not forgotten your question. I'm circling back to it. The reason it's the gold standard, I think, is because any accused who reads that will not be hampered in his defense. He knows exactly what he's accused of doing wrong, exactly what they claim he caused the death, and exactly what's going to be confronting him at trial. So in this case, we have a list.
But is the state required to give you exact notice or is it's fair notice?
Reason 2115 answers that for us. It says reasonable certainty.
Reasonable certainty. And going back to Mr. Guerra's argument,
Yes.
which is that at trial, they don't have to put all their evidence in an indictment. At trial, they could bring up evidence and circumstances that would make even speeding reckless. So wouldn't the requirement of the while conditional language really hamstring the state in terms of the kind of case they can present?
It'd make their job a little harder, but I think when we're talking about somebody who's facing 20 years, it probably should be harder for them. So I guess I'm not real sympathetic to that argument because I think Justice Rios brought up a very good point. That when we have the indictments that we're confronted with today, the defense is at the disadvantage of, for example, in these type of cases, there's very often accident reconstruction.
Mhm.
And you get an expert and he analyzes, was there recklessness? Was there a gross deviation from a standard of care, right? And the only way of telling that is what are they claiming he did? And when they say that he was driving at a speed that was unreasonable under infinite number of circumstances, but they were just not the perfect circumstances here. I think number one, our expert is at a real disadvantage because he doesn't know what his expertise is being called on to examine. Number two, these allegations are so disparate. The list of them, that you don't really know what, it's a shotgun approach almost. You throw everything out there and without elaboration. And I think that when you don't, look, 2115 required, I keep come back to it. And I'm gonna detour a little bit and elaborate on 2115. I know I sound like I'm all over the place. I'm sorry. I haven't argued here so long. 2115. I think y'all, justices, you'll grant me this. It is an especially hardly worded statute. Okay, we have a requirement that a defendant be put on notice for what he's going to be put on trial for, right? Intentionally knowing the bare bones allegation is sufficient. But when it comes to recklessness, the Texas legislature said, oh, no, there's something about this state of mind that we are going to insist that it be very rigidly pled because of all the synonyms adjectives, of all the adjectives they could have used to put the state to its pleading burden. They used the term certainty. I can think of no stronger adjective than, or noun, I guess, than certainty. That means there can be no doubt as to what the defendant's conduct was. This court recognized it in Flores versus State.
So did you, Mr. Contreras, do you disagree with this distinction that the state is drawing between result versus circumstances?
Justice McCray, I'm glad you asked that. I 100% disagree with that.
And can you not find that distinction in the case law like the state has pointed out?
I spent a lot of time, he's talking about the doctrine of offense conduct. And I don't mean patronize or anything, but it's all offenses are broken down into three categories: the result-oriented nature of conduct, circumstance of conduct. They fall into one of those three. And why do we have those distinctions? You'll not find one single published opinion or unpublished opinion, not one in the Southwest Seconds, Thirds, or First, that say the reason we have that distinction is for pleading rules. No. It's called offense conduct. It's the general broad term of the three categories. It's offense conduct. Offense conduct doctrine is used to determine whether or not the jury charge, when the case is given to a jury, whether or not the application paragraph of the jury charge matches what was charged in the indictment. It has nothing to do with the particularity required in pleadings. I will grant the state that was a very novel argument, but it's been published in only one place, and that's in their brief, nowhere else. I think the court is going into very dangerous territory if it adopts a novel, unproven theory or tool or
But
formula.
wouldn't we be doing that if we required conditional language?
And conditional.
Wouldn't we be going out on a plank and kind of creating some new law if we required conditional language in order to meet reckless?
I guess I'm not quite getting by conditional.
The while.
Oh, wow. No, I don't think while is required. I'm just saying that's just an example of a very, very well, no doubt.
You're not taking the position that that's a deficiency here.
No, I am not. I'm just saying that that's very well worded without no doubt in the way it was charged.
So how could this indictment pass Mr. Contreras' muster?
Okay.
How should it have been pled?
I talked a little bit about my brief. I think that number one, when you we could focus on speeding, but do y'all mind if I jump around and say some of the other manner of means? Some of them are a little easier. Some of them are worse than others, I think. For example, when you allege that someone caused the death because they were speaking on they were using a handheld device, that does not, you can be driving down the road on a handheld device and someone runs a red light and you crash into them. You need to elaborate. You were holding a handheld device straight off the road and crashed into oncoming traffic. No doubt that's what you did, because we're talking about distraction. The cell phones always leads to distraction that leads to you doing something improper. And then let's jump to the first allegation. Circumstances then existing. If they just laid out what circumstances they meant, what did they mean? Was it because it was bumper to bumper traffic, because traffic had slowed? And Mr. Garrett, the state, says that really works a hardship on the state. you know what? The state's not going to serve any time in prison. My client, well, if he's convicted,
Well, so,
it should work a hardship.
so let me ask you
Yes.
whether you agree with this statement out of the Flores opinion. And I'll quote, Flores admits in his brief that the amended indictment in this case would have complied with 2115 if it had alleged the three acts of reckless behavior conjunctively instead of disjunctively. So in this particular case, in spite of what the state is telling us, if all of these were alleged conjunctively, wouldn't that be describing the circumstance? If they're able to prove all of them, doesn't this give you sufficient notice?
If, I'm sorry,
If
I'm not
it's
cutting you. I
pled conjunctively, like the Flores decision says, the indictment would have been sufficient.
I'm again going to disagree with the state. I think they presented you, they fall incorrect holding in Flores. Well, the state said it was an indispensable part of the Flores decision that it was pled disjunctive. That is not correct. Read the opinion very carefully, and I have read it more times than I care to admit. It mentions the defense counsel raised as one of his objections that it was pled disjunctively. But then when you go down to their holding, it has nothing, it mentions nothing about the disjunctive. The state claims that that was central to its holding. It was not, and I urge you to read it. It was not central or a component of its holding whatsoever. But Justice McCray, you said, wouldn't it matter if it was conjunctive? It would matter if they were required to prove every one of them and submit to the jury that you must find all of these true beyond a reasonable doubt.
But that would be a sufficiency analysis. It wouldn't be whether the indictment gives notice or not. That would be the charge analysis or whether the evidence is sufficient under the way the jury is charged.
But I guess what I'm saying as a practical matter, whether you plead disjunctive or conjunctive doesn't matter because of the way it's submitted to a jury, right? They can each of them, the jury can decide on any one of them and reach a verdict based on those alone. But one of the five manner and means.
Right, but we're talking about the sufficiency of the indictment to give notice.
Right.
And if you say the state intends to prove and, how does that not give you notice to be able to prepare here?
Because the separate lines are all so disparate and have nothing to do with each other. It's a shotgun approach.
Well,
Each one's, I think they should be looked at standing alone. I guess is my answer.
But you're saying if they use the while, if they use speeding, failure to keep a proper lookout, failure to turn away while intoxicated.
I think that I refer to it as a narrative type description of the reckless conduct. I think that would cure everything. I think nobody could complain. I have 11 seconds. There's not really anything to say, except I hope you'll have a good day.
Thank you.
Thank you all very much.
Thank you.
Mr. Gedai, you have 10 minutes.
Your Honor, I want to respond to the idea of while being extremely important in the Townsley decision by telling you about my morning. Today I woke up, brushed my teeth, showered, got dressed, ate breakfast, came to court. Here I am. Is there anybody here in this room that thinks that I only did one of those things? And I think that that establishes how unworkable this whole idea of ors and ands in indictment is that we get from the Rodriguez decision. And in fact, what if, for example, let's say it's an offense to come to court here, a reckless offense, and maybe it is. What if I'm charged with recklessly waking up, coming to court, and all those were my manner and means? But what if during trial it comes out that I brushed my teeth in the shower? So now while is important, but it wasn't beforehand, because those are evidentiary matters. Because when you describe an offense and an indictment as a narrative, what you're doing is you're providing evidence. That's what the narrative is. It's the story of the case that both defense has and that the state has. So I just wanted to very briefly respond to that argument about Townsley. I disagree. I don't think that while is an extremely or even a very important part of that indictment at all. I think that it's rather synonymous with the word and. To continue and go even further, we have, I just want to briefly touch on Ramos, and I understand that Ramos is not exactly on point. I was just utilizing that case to argue the point that evidentiary matters are not something that the state must plead in indictments. And I do agree with defense. We do plead in the disjunctive and charge in the conjunctive. And that's, I think, one of the reasons Ramos has caused such consternation amongst prosecutors when it comes to indicting these cases. Excuse me, Ramos, Floyd, the Floyd court decision. Thank you, Your Honors. So moving on. Well, Townsley. I think that this idea of whether an indictment or conjunctive or disjunctive lays bare how unworkable this decision Flores is. And I'll give you another example. Townsley, his acts were that he attempted to elude a police officer while, drove a motor vehicle at excessive speed while attempting to elude a police officer. Now, elude doesn't mean flee. Elude means to avoid. Elude isn't to run away, causing great danger. To elude is to turn the corner and maybe not see an attorney at the grocery store because I don't feel like having them see me in my wolf t-shirt. That's elude. And I can tell you there were many circumstances where eluding somebody is not reckless. And the same goes for speeding. And that's why this indictment is unworkable, because using the appellee's argument on how to do these cases, it indicates when you go through them and you try to categorize each word one way or another, it's completely unworkable. I think under appellee's analysis, we wouldn't have a good indictment under Townsley. Under appellee's analysis, we wouldn't have a good indictment under Arredondo. We have grabbed the steering wheel and pulled it to the right while a passenger in the front seat. There are many, like I said before, there are many circumstances where that is not reckless. And that's the unworkable problem that we get when we start applying 2115 broadly without considering the type of offense it is. And I also want to briefly respond by reading y'all.
Let me ask you this, Mr. Guerra.
Yes.
Are you asking us to overrule Flores? Do you think it has precedential value for this court such that we would have to overrule it?
In my second argument, in my alternative argument, yes, Your Honor, I am asking that. I tried to phrase it more politely to put it into alignment. And I don't necessarily think that y'all would be overruling it, because I do believe that the part in Flores that we are, that's at issue here is dictum.
So, but I think also I heard you make the contention that it might not even be good law now because it's been effectively overruled by subsequent decisions, or no?
Oh, no, with respect to Bexar County and the fourth court, it's still the law. However, in I believe one of the Houston courts of criminal appeals, I think the 7th or the 14th court, and also in the Waco Court of Criminal Appeals, and I can file a letter after the brief, but there are numerous other cases.
But you're not taking the position that subsequent Court of Criminal Appeals opinions.
Oh, no.
Okay, got it.
No, Justice Brissett, not at all. I am not taking that opinion. The CCA has not given us any answers on this since Rodriguez. And so we've been out on our own.
What about charging that the defendant was driving and operating a motor vehicle while operating a mobile device? What about that gives the defendant notice of what, because that could, again, as Mr. Contreras raised, could be an innocent act, operating a mobile device. So how does that comply with 2115 and being, providing reasonable certainty?
Reasonable certainty. It's because
Alleging reasonable certainty.
Thank you, Justice Rios. if we were to focus solely on that allegation, we have to recall that the indictment, or it doesn't just say that the defendant drove while, you'll excuse me for just summarizing, talking on a cell phone. It says he caused the death of a person by doing that. And that indicates to him, as far as notice goes, that his behavior while on the phone was reckless enough to do that. There are multiple ways to drive while looking at a phone. I do actually think that it's likely an offense to drive while using a cell phone in Bexar County, or at least in San Antonio's municipality. But when you read that, when the state comes to you and says, you killed somebody because you did this, I think that the defendant can understand that that particular act is the act we're looking at, and that the way he did that act was reckless. And that evidence concerning the circumstances of that recklessness with respect to a result of conduct crime, those are going to be the facts in the case. The jury will look at the evidence and will decide whether they agree with our narrative or the defense's.
So if the result is the only thing you look at, you're saying you don't have to plead in a way that gives them notice of the fact that, or how they disregarded the risk, knew and disregarded the risk?
Knew and disregarded the risk that the result of the conduct would occur. Well, the statute only requires that we allege the acts that constitute recklessness. And it's my assertion that to constitute recklessness is to just be a part of it. And so it's my assertion that indeed, if you were to just solely allege that should be sufficient. I'm thinking.
And then it comes down to the evidence presented at trial, whether it's sufficient to charge.
That's correct. Because if we talk to our witnesses and we understand that every person has a different story. One witness might say he was going 40, he was fine. Another witness might say he was speeding. And I can't fathom a trial where the prosecutor would decide which witness during an interview when preparing a case is right and which is wrong and put those into the indictment and then ignore and then put all the other ones into the trial. That doesn't, to me, seem like a productive way to handle a trial. And I briefly, if you wouldn't mind, Your Honors, I'd like to just read you a line from a case. This is from Smith v. State. This is, the pin side is 14 on that case. And the line is, as a part of enacting legislation of the 1974 Penal Code, the legislature amended Article 2115 to accommodate the Penal Code's inclusion of the culpable mental state of recklessness, and that would be 603C. Since the legislature modified Article 2115 as a part of the same legislation that enacted the 1974 Penal Code, it must have been aware of the terms of Section 603 of the Penal Code and intended for Article 2115 to be given effect. That is the law and case law that I stand on when I say Article 2115 must be considered in harmony with 603C. Your Honors, I'm done. Do you all have any questions for me?
I have one more. One of the
Yes,
acts
Justice McCray.
that you've alleged is that Mr. Contreras was driving and operating a motor vehicle after the introduction of a controlled substance into the body, but the indictment here does not identify the controlled substance. So how can we determine if this alleged act demonstrates that Mr. Contreras was reckless without knowing what the substance is?
Well, Mr. Contreras was notified that the substance he had ingested at the time he was driving was a controlled one that the government deems to be unsafe to have freely. I think that indicates there a certain amount of recklessness, but I also, I think that conveys it, because we're also saying he did this, he had a substance in his body, and he caused a person to die. He caused a death. And so all of those things indicate it. I've noticed that I'm out of time, but I do want to answer your question, Justice McCray. Did I answer it correctly? Okay,
Yes,
for you.
thank you.
Thank you. Thank you all very much.
Thank you very much. Been a very good oral argument. I think all of you, both of you, you've certainly given us a lot to think about. You will be notified when the court issues an opinion in this case. So thank you very much, and we are adjourned.